I am going to allow Mr. Campbell to withdraw. Mr. Goheen Rango, I was present in court when you elicited that attorney-client privilege had been violated, and that you felt prejudiced by that. I don't think we can walk that back. That way.
Brandon Campbell, I don't recommend you speak in open court, and if you have questions about speedy trial, we can discuss them when I come into the court here. Between this week and
Thank you, Brandon. I'm still just talking with the judge. Thank you.
Just
So
to be clear, it's against my advice to talk to the judge because he's not
I understand that.
give you advice.
Campbell's statements on the record, your statements on the record were that your attorney-client privilege had been violated, which is not revocable. I can't ask why it was violated because, again, that's attorney-client privilege. So you invoked that in open court after it was already the perception of the court that the relationship between you and Mr. Campbell.
Right out of the gate, you can feel the uncertainty creeping in. The defendant is already questioning whether he can represent himself effectively while in custody, and that's a major red flag. Self-representation, also known as pro se, is legally allowed, but it comes with serious risks. Limited access to legal resources, restricted communication, and procedural confusion can quickly turn a defense into a disaster. So here's the question for you: should courts do more to discourage self-representation when someone clearly isn't prepared?
Mr. Campbell, go ahead.
Your Honor, I've had an opportunity to speak with Mr. Goheen Rango this morning. I had an expectation based off of some recent meetings, in this case, about how today's court hearing was going to proceed. And unfortunately, those expectations are not how we're going to proceed. I don't know how I can ethically proceed today, as I'm having either a breakdown in communication with my client or he's incapable of assisting me. So Mr. Ringo objects to a 1077 being filed. He doesn't believe he needs it. He's told me he's passed 3 1077 evaluations. I'm not able to communicate with him today. It's much different than how I communicated with him on the 11th. So, I expected to be able to proceed. Our communication has been well while he has been in custody, and I've been able to do it in person. It has not been well today. He wants me to make oral records about motions that may not have good faith basis. They may. I can talk to him about that in greater detail, which is what I have done. I've also offered to set the matter for trial today. But I'm concerned about any kind of affirmative action taken on behalf of Mr. Goheen Rango, because he's also told me at points that he wants me to be fired, or that I've asked him if he wants me to withdraw and him to proceed in his own capacity. I don't know how to proceed. So
why don't we do this for today? Why don't we set this over 1 week? It sounds like you've had good. I'll get to you in just a sec, Cleve. I do see you have your hand raised.
Thanks. Before, Your Honor, before you make the decision, I think that what I have to say may affect what you're about to say. So I'd appreciate, because I did have my hand up a couple minutes ago, just briefly based on what Brandon had just spoken on the record.
Okay, go ahead.
Thank you. So a couple of things I disagree with. He said, unfortunately. I don't think it's unfortunate what was communicated today in our breakout room. I did think that he shouldn't have shared some of the details that he's already, it's too late now because he just put it on the public record. But I think it may have violated my attorney-client privilege too. All I was asking my attorney to do was to make a public record today before Your Honor about the fact that my signature is not on any of the previous in the last 2 years waivers of my speedy trial. And I was asking him, I thought it was a pretty competent legal question, if that makes it a legal document without my signature. I didn't know I was getting ready to be pressed into a 1077 peripheral, territory there. I didn't think it had to do with mental deficiencies myself. Thought it was an intelligent question. Maybe I'm wrong. The second part is, I do believe that the state is well aware, and according to rules of professional conduct for her, that she may be in dangerous territory toward prosecutorial misconduct. Taxpayer dollars are the ones that are paying for any of these proceedings to happen. Your Honor knows that well. Rule 8.3 says that if there is insufficient evidence for any of the undisputed facts in a case, prima facie, that the state knowingly, especially a prosecutor, would be in violation of her moral and ethical obligations, Supreme Court rulings, to pursue justice and not just to merely gain a conviction. The trouble with my understanding in this is there's no evidence in a malicious mischief, and I think that's the one of the cases that I'm up against here today. I'd asked my attorney briefly. We didn't have enough time to talk, and we've talked about this before. If it's his professional opinion, if there is a possibility that I would even be found guilty if I did go to trial, he's in a different persuasion than I am, I guess. He thinks that maybe there is sufficient evidence. I don't believe there is. I asked for video evidence. There is none. They can't retrieve it. My own investigator can't. So if the defense can't have any sufficient evidence, that leads me to believe that probably the prosecutor doesn't have the ability to get that video. And if she is able to get the video, then I mean, we get the video too, right? So that, and I don't mean to frustrate Your Honor or Miss Carney or Brandon. I'm not a legal professional. I'm kind of the one in the hot seat here, so all these questions are relevant to me. I'm thinking he's thinking that they're not relevant, but I mean, in the last 2 years, if taxpayers are the ones paying for all this, it's still getting continued out over and over and over again. I've had 2 different attorneys on it. It seems like it's an arbitrary thing, and that maybe I don't know. Before I go any further, thanks for letting me speak today.
Well, Your Honor, I do have a brief matter to raise to the attention of the court. At this point, the client has asserted what I believe is an unwaivable conflict, in that he has belief that I have waived attorney-client privilege. And so, I mean, we can set it over a week, and in that time, I'll make contact with my carrier in the bar. But I mean, I don't believe I have done that. But I don't know how I can proceed ethically on his behalf in these cases based off of that statement.
So, courts at this time, Mr. Goheen Ringo has been coming in front of this court as long as I've been on the bench. So, back to 2021. I would say he's not being held on any of our battleground cases. His holds are all Superior Court related. Certainly,
This moment is incredibly important. The judge is pointing out that attorney-client privilege may have been compromised, and once that happens in open court, it can't simply be undone. That's huge. Privilege is one of the strongest protections a defendant has, and when it's publicly questioned, it creates tension not just legally but strategically. Now think about this. If your own lawyer believes the relationship is compromised, how can they effectively defend you?
Maybe compelling legal reasons for a person, if they are pending felony charges, to not proceed on misdemeanor charges first. Ultimately, it's a decision of the defendant and a decision of the attorney. I think what we will do today is, I don't think we're going to resolve this to anyone's satisfaction on a video docket, is I will have Mr. Campbell meet with Mr. Goheen Ringo. If it is determined between the two of them that they are not able to proceed together, I don't know if the court has other options available that Mr. Goheen Ringo is not conflicted with. But we will cross that bridge when we come to it. Again, at this point, there's no prejudice, there's no hold, and speedy trial is commencing today. So I don't see any kind of immediate reason for rash decisions on the record. That said, if we come to that accord next week and the court has to make some additional decisions, we will get something else figured out at that stage. So, Mr. Goheen Ringo, we're going to see you next week, sir, on this matter. That is the 24th, and we'll go from there, okay?
Thank you, Your Honor. I did have a question for you. On the points that I brought up, has Your Honor formed any opinion about any possibility of, you think there may be some prosecutorial misconduct going on, or maybe that taxpayer dollars aren't being correctly appropriated in this? It's been over 2 years. We're talking about, did you say, a misdemeanor thing? And I was wondering how relevant of a point it is that none of my signatures are on those documents.
So certainly, Mr. Goheen Rango, those matters can be brought to the court's attention via a motion.
Okay.
I will tell you that a person's oral statements regarding waiving speedy trial and so forth in misdemeanor municipal court can replace a need for a signature. The court has audio records of each time the court has advised you about your right to speedy trial. Generally, I will walk you through that. Again, you and I have had very intelligent conversations in the past about speedy trial. So while I understand maybe from a superior court perspective, why a quote unquote wet signature would have meaning, I don't think that if another judicial officer looked at this with the audio and video records in regards to those waivers, that they would find that you needed to have an actual physical signature on those documents. So I'm just letting you know that I think that would be my perspective on that. Certainly an appellate court at the conclusion of your matters, if you did choose to appeal that matter, certainly in Superior Court in Clark County or the State Court of Appeals could make a different decision, but that would be my educated guess, at least at this time.
Okay, and that's actually what Mr. Campbell told me. So going toward his knowledge, the inner workings and stuff, I didn't doubt him or anything. So that does answer my question on that for sure.
All right, so I'm gonna just get your different cause numbers, Mr. Goheen Rango, on this set over form for next week, and we'll see you next week and go from there. Okay, sir? All right. Good morning, Mr. Goheen Rango.
Good morning, Mr. Wheeler. Yeah.
And Your
Morning,
Honor,
Miss Carney.
I'm here on behalf of my client, Mr. Goheen Rango. I have filed a motion, which I understand Your Honor has reviewed. I still maintain that there is an irreconcilable breakdown in the attorney-client relationship. I do want to provide some information to the court. Spoken with Mr. Goheen Rango this morning. He believes that our breakdown in communication and our issues as far as it relates to our attorney-client relationship are capable of being repaired. I am being truthful to the court that I disagree with that assessment. However, I want to be fair to Mr. Goheen and let the court know that. He's asking that we set this matter over to next week for me to go and see him in custody in the jail. I would have seen him this week, and I don't want to get into there was a miscommunication between he and I. I thought he supported this motion based off of certain factors that I'm not going to get into. He no longer does. I'm welcome. I think I'm back next week, but even if I'm not, I'm welcome to come back next week if it was set over for he and I to talk in person in the jail. I do not believe, I don't have a good faith basis that any discussion that he and I have will change my position as to the breakdown, particularly relating to one issue that I'm not capable of ethically discussing with Your Honor, and a second issue which was discussed in open court relating to my or to the client's belief that I've waived attorney-client privilege. I believe that raises an unwaivable conflict, which I've already been frank with the client about. That being said, he's also asked me potentially about moving forward pro se. I have strongly advised him against that. I don't believe it's a good idea for any client to represent themselves, but he also has a significant experience with litigation. He's been in jury trials, I think, and as well has had lengthy, time to basically research these matters in the law library. And so we are here today. I'm still supporting a motion to withdraw, and I just wanted to provide Mr. Goheen Rango's perspective to the court. So I don't know if he wants to speak or not.
So I think my thought is, Mr. Campbell, if you are willing to meet with Mr. Goheen Rango, it sounds like sometime before court next Thursday, I don't think anything will be lost if indeed after that your position is the same. I think the court would, at that point, allow your withdrawal. But I want to give every opportunity for this to hopefully work. So I'm going to be setting this matter over 1 week. That takes us out to the 8th of May.
And Your Honor, I haven't reviewed the matter for speedy trial issues this morning, so I'm not sure. I think the waiver was to the 14th of
Mr.
April.
Goheen-Rango is not being held on any of our cases. He's in a 90-day speedy trial with commencement dates, I want to say, on the 24th of April. So we're not very far into speedy trial.
And I for some reason, this file, I have other files I think back that may have it, but I believe the commencement date may be the 14th of April. But
let me take a quick look here, seeing as we have the files right here. For the speedy trial waiver that I can see all 3 cause numbers on has April 17th,
right,
2025. So even if we set out to May 8th on a 90-day speedy.
Now we're seeing a complete breakdown in communication between attorney and client, and in legal terms, that's a serious problem. The attorney is basically saying, I don't know how to ethically proceed. That's not just frustration, that's a professional boundary. If a lawyer feels they can't act in good faith or properly represent their client, withdrawal becomes necessary. But here's the twist: what happens when the client doesn't agree? That's where things get messy fast.
The trial calendar, we're not even 30 days into speedy trial. We need you to go ahead and set matters for trial.
Thank you, Your Honor. I just wanted to be clear on that point.
All right.
Your Honor.
Yes, Mr. Goheen-Rango?
Hey, just had a quick question. I've been hearing that term a lot today, speedy trial. And I took 3 years of AP government politics in high school. I'm sort of roughly familiar with some constitutionality about that, but I'm just curious today if you could give me something to think on for the next week till I talk with Brandon. As far as for the position of a defendant, what's the purpose of a speedy trial? And why does it have to be speedy?
I think what was happening, Mr. Goheen-Rango, historically was people were languishing in jail with no definitive time frame. And certainly there's been times where speedy trial has been suspended. Most recently, I think, when there was an emergency order during COVID, speedy trial was suspended at that time just because we couldn't safely impanel juries. So generally, a person who is in custody has the right to be brought to trial within 60 days. Does not mean that's always the best strategic choice, depending on the complexity of the case. And a person who's out of custody generally has to be brought to trial within 90 days. Certainly, that is a privilege or a right, that a defendant can choose to waive. And a judge like myself, whether it be over Zoom or in person, is going to make a colloquy with that person, making sure that they understand their right to speedy trial, making sure that they understand that from the new commencement date, so in your case, when we last did the speedy trial waiver, that you understood the 90-day time frame for the particular cases would run from April 17th. And ultimately, it's the defendant's choice whether that speedy trial time frame be waived. So that would be my recitation on that.
Okay.
Thank you, sir.
Yeah, thank you. Since can you hear me? Oh, sorry, I got muted there for a second. Since my case here in Superior Court,
Please, this is your attorney currently, Brandon Campbell. I don't recommend you speak no court, and if you have questions about speedy trial, we can discuss them when I come into the court or come into the jail between this week and next.
Thank you, Brandon. I'm still just talking with the judge. Thank you.
Just
So
to be clear, it's against my advice to talk to the judge because he's not.
I understand that.
Give you advice.
All right, I'm gonna try to get back on my train of thought here before my turn is over. I have a court matter that I'm currently facing right now here in Superior Court. I don't need to go into detail about it. It is a false allegation, and I've been sitting in jail, languishing for 7 months. Meanwhile, my attorney in that case, which is not Brandon Campbell, Brandon has been awesome. He comes to see me often. he's seen me more times in the short amount of time that he's been my attorney than altogether twice the amount of time than my other attorney who refuses to come and see. It's been 5.5 months since she's been here to see me. And so I'm wondering how I could still be languishing. Yes, it's a different case about a superior court matter, but without being able to work on my case here. I know you've released me, which is very gracious, and I always thank you for that on the older cases. But since these cases preceded my involvement in this newer case 7 months ago, when I was attacked, and then the police they arrested the wrong person and never got my side of the story.
I really recommend you don't speak about this on the record.
And I think, Mr. Goheen Ringo, where I'm going to go with this is, it's this thing that I tell everyone in the courtroom today, and if you were present in the courtroom, one of the things that a judicial officer cannot do is provide legal advice. And I think you're asking me to provide legal advice or to make a ruling on a case that I don't have any information on. Certainly, those are issues very clearly that need to be brought up with your assigned attorney. I can't make a ruling or provide legal advice on a case that is not before the court.
I understand that.
I would additionally also say, like Mr. Campbell is, you are on a record, you are making statements, and if that attorney were here, I'm sure they would ask you not to make any statements that might be against interest. So that concludes your hearing. Thank you, Mr. Goheen Ringo. I'll see you next week, sir.
Thank you. Mr. Judge Wheeler.
Go ahead, Mr. Campbell.
I don't, I'm sure Your Honor may recall some of the discussion in last hearings regards to defense's motion for counsel's request to withdraw. I've had opportunity to speak with Mr. Goheen Ringo in custody since that last hearing last week. I still have a good faith basis to indicate there is not a pathway moving forward to repair our relationship, in my opinion. The client, I believe, over my objection, wants to make an oral record of his own. So I'll defer to him if he's going to do that, but did provide him an opportunity for me to provide to the court his presentation to protect his right to remain silent. But ultimately, I believe that there is the perception of an unwaivable conflict based off of the client's statement that I waived his attorney-client privilege, damaging his case. And even if I disagree with that assessment, there are certain waivable conflicts that I am not capable of overcoming these conflicts with the client. In my opinion, I don't believe the client is able of overcoming my concerns. And so those are the grounds upon which I'm seeking to withdraw. I have done a little bit of research on the case law surrounding these types of circumstances where a client is objecting potentially to counsel's withdrawal. I have not. I could, if Your Honor has concerns about that, I can put those into writing or recall the matter. But ultimately, I believe that at this point, my counsel of Mr. Goheen Ringo should be ordered withdrawn, and counsel should be substituted in for his trial in these matters.
This is where the defendant tries to shift the narrative, raising concerns about prosecutorial misconduct and lack of evidence. Now on the surface, those are valid legal arguments, but timing and delivery matter. Courts rely on structured motions, not off-the-cuff claims during hearings. Without proper filings or supporting evidence, these arguments lose weight instantly. So the real question is, does he actually have a strong legal point, or is he undermining himself by presenting it the wrong way?
My question, Mr. Goheen Ringo, because I know it had been floated to the court two different ways. One way was that you were choosing to represent yourself now. The second would be if you are asking the court to assign you a new attorney. So my first question is, are you planning to represent yourself at this stage, or are you asking the court to appoint you another attorney?
That's a really good question. That kind of cuts me off from what my train of thought was going. I had a question that maybe should go before that question, but I was just wondering, Is that all that's necessary for a judge to remove a an attorney? Is that just whether it's true or not? Someone who's been accused of a crime can just simply mention that he believes that an attorney has violated his attorney-client privilege, and that's all it takes to have that attorney removed.
No, because even prior to that time, you
Yeah.
were expressing to the court that very day that you believed that Mr. Campbell was not working in your best interest.
Okay.
It seems that apparently that morning there had been some conflict between you and Mr. Campbell of some nature prior to the court proceeding. Again, I'm not privy to that. It sounded like both
Yeah.
people.
There was no conflict. There was no
Again,
conflict.
But again, after that proceeding, after Mr. Campbell's statements on the record, your statements on the record were that your attorney-client privilege had been violated, which is not revocable. I can't ask why it was violated because again, that's attorney-client privilege. So you invoked that in open court after it was already the perception of the court that the relationship between you and Mr. Campbell had broken down. So again, the court can withdraw an attorney based on the intractability of the relationship between the defense attorney and the defendant. But I think when we add on top of that, also statements that attorney-client privilege had been violated and there was an intractable relationship at that stage, I think that seals the deal. So
I didn't know. I definitely wouldn't have said those things had I known that this would be the consequence. My concern with it, if I can recollect where my train of thought was that day, was I thought he had mentioned a few details that I didn't want mentioned on the court. I think if I went back,
and again, we're not going to go into that today because if indeed those details were subject to attorney-client privilege, we're not going to restate them and point out to them which ones you thought they were, because again, you would be you'd be invoking things that you said were privileged to the court on the record in open court. So where we are going with this is a very simple question. Are you asking to represent yourself moving forward, or are you asking the court to assign you another attorney?
I think I would like to be assigned an attorney. Now, hold on. Actually, if I represent myself, will I have facilities to be able to do that while I'm in custody here, or can I be sent a packet on instruction how to do this? Because I don't know. Might be interested in that.
The court cannot provide you materials in good conscience that.
The judge here is doing something very strategic, slowing everything down. Instead of forcing a decision, the court is giving both sides time to regroup. That's actually a sign of judicial control. When emotions are high and communication breaks down, rushing can lead to appeals or reversible errors. But here what stands out, the judge makes it clear there's no immediate prejudice. Translation: the system isn't against the defendant yet, it's giving him a chance to fix this.
That are not already available at the Clark County Jail and what is provided there. That would be the court inserting itself into your defense, and the court is an impartial fact finder. The court's responsibility is not to assist people in self-representation. So the issue that this court has is there's a conflict with every existing attorney that this court has with you, or a conflict based on we don't have anyone left. So the court is going to have to explore in the next week whether we can find an attorney in Clark County that will accept representation. I'm not going to go any further than that, but that's the status of the court. So I think we're going to have to set this matter over 1 week, and the court will have to reach out and determine if we can find counsel. Yes, Mr. Goheen.
Is there, there's a few attorneys that my mom's been supporting me throughout all this. She's been in contact with. Would it be possible to have them apply personally, or is it just only on the court's behalf to go seek one out? In other words, can one volunteer, one that we've been talking with, or?
It would have to be a licensed attorney
Of course, yeah.
in the state of Washington that has some background in criminal defense. Certainly
Okay.
not to have a tax attorney in here trying to navigate a jury trial.
Yeah.
But if there is an attorney that you are aware of that is wanting to accept your defense or availability
Yes,
in
sir.
court, that's where we'll go. But
Okay. So, and then they just have to show up, or like on the Zoom or in person on the next setting.
they would have to contact the court prior to the next setting. The court would have to vet whomever this is, vet their availability, and so forth. So it can't be a surprise guest behind door number 3. It has to be someone who has contacted the court. We're going to see you again next Thursday in 7 days, and we'll see what we can do. Okay.
And Your Honor,
All right. Thank you, Your Honor.
I just wanted to check our speedy. I don't have the commencement right in front of me.
I want to say is April 17th.
Okay.
So we are going to be 30 days elapsed.
Great,
Mr.
okay.
Goheen Rango is not being held on these matters. Let me look though. I remember that the waiver, let's see,
I have it entered.
April 17th,
Okay.
2025, entered February 20th, 2025.
Thank
so
you.
we
Okay.
are 32 days elapsed next Thursday, the 15th. Ms. Carmi, do you have an objection of this matter coming back next week? I know that you are not personally going to be present for, I suppose, the assignment of counsel. My recollection, if we have withdrawal, is that speedy trial will recommence with the assigning of a new attorney.
Yeah, I have no objection to this being heard next week.
Okay. All right, Mr. Goheen Rango, we are going to see you next week, sir, and we will work on getting you counsel. Thank you.
Thank you, Your Honor.
Yep.
Thank you, Ms. Carmi.
Thank you.
This case is a perfect example of how courtroom dynamics, not just evidence, can shape the outcome. What started as a manageable legal situation has turned into a complicated web of miscommunication, distrust, and procedural missteps. The judge remained measured, the attorney raised legitimate ethical concerns, and the defendant, despite asking important questions, struggled to navigate the system effectively. The biggest takeaway: knowing your rights isn't enough, you have to understand how to use them correctly within the legal system. Backhand index pointing right. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.